Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West, transmitting across the internet. This is episode 292 of Registry Matters. Good evening, gentlemen. How are you?
Good. Good evening, Andy.
Good evening, and how are you? I am doing awesome. Our legislature is kicking ass.
And yours is like 3 days long or something?
30 days.
30 days. It started when?
January 16th.
So you're like in kind of like the closing days then almost.
Yeah, we got 13 days to go.
Do you do crossover?
No, we don't have a crossover. It can cross over at any point.
Georgia has a crossover day, and that's like a big deal. And if you can keep it from crossing over, then you've kind of won.
Theoretically, but not necessarily, because you can take something that didn't cross over, and you can apply it to you can do an amendment to a bill that has crossed over, and using the language in the bill that didn't make it through crossover, if you find somebody who's willing to have that attached as amendment. So it's not necessarily the end of legislation that didn't cross over.
At dinner, I was trying to explain to my kid about the topic for the evening of what we're going to talk about, of frightening at high. And God, just trying to describe, saying, so there's this thing at the lower court that, and then it gets higher. And I was like, oh my God, it's so wonky and complicated, Larry, to just try and explain to someone's like, well, hey, what are you going to talk about tonight? It's ridiculous. And that, along with trying to explain how committees work to then go to this goofy procedural thing that is a crossover, and some states have them, some states don't. You don't. Then there's Nebraska with the unicameral body.
That's correct.
Oh my God, it's just
only
ridiculous.
one in the nation. They have 49 senators. They only have one chamber.
Chance, are you experienced with going down and testifying and whatnot with the legislature?
Yes, I am.
Oh, well, very good.
I've done
perfect.
it.
Oh, have you? God, that's then you're like a hero. You're one of the rock stars.
But, yes, I have been involved in doing that type of thing.
Well, make sure that you go over and press like and subscribe over on YouTube and leave 5-star reviews on whatever podcast app most people use. Apple Podcast, I guess it's called. So please go leave a review over there. That would be, if you do nothing else, that would be the free way to support the show. And make sure that you do the thumbs up stuff on YouTube, everything, all that stuff. Subscribe with your podcast app. All that stuff would help out if you would contribute that way. So, Larry, what do we do in this episode?
We have a multitude of things for this episode. We're going to be taking some questions, a comment from the audience, and we have a few articles we're not going to get to. I can see that now. We plan to discuss frightening and high recidivism and the question about how that fact was determined and the relevance of that fact in terms of the Smith versus Doe presidential decision.
You could kind of say it not really a fact.
Well, it is a fact.
It's just not really a true fact.
But it's a
that
fact.
Is correct.
It's the law of the case.
Yes, I get that. But that, Larry, we have learned recently that the more times you say the untrue things, the closer they are to the truth. If you keep repeating it, it becomes true.
So, well, and before we get started, just remind the audience we have the 182-year-old Larry, but we also have a person less than half that age named Chance Oberstein, who's an attorney who practices in the state of California. So
182. Chance, you're 90 something?
Pretty close.
Wow.
Close.
Jesus, man.
So we have the opinion now of a lawyer on Registry Matters Podcast.
Fantastic. Well, let's dive in with this first comment from a person. This one's fun, Larry. I was like, oh, that's kind of an interesting person that we have in our ranks as a listener. It says, I will keep this brief, but I will say you failed at it. I am a former deputy U.S. Marshal who is now on the registry. Naturally, I listen to your podcast and stay up to date on the latest trends and emerging attitudes in the field. I was listening to RM292, and I felt inclined to contact you. While I am now a PFR and must deal with the collateral consequences of my choices, I have to step in and provide some feedback on a comment that was made on the show about license plate readers. I guess we were talking about the woman that was getting arrested, the young woman who was getting arrested, and how would they spot her car? That's what we were talking about.
Yes, you had opined that it was likely from a license plate reader, and I didn't have any information on that, but it could have been for any number of things, pretextual stops. But go ahead.
Yep. The episode provided a lot of sound advice in terms of invoking your Fifth Amendment right as well as being brief, and I agree with all of this. What I disagree with is the statement saying they're not just running every license plate that goes down the road. They pulled her over because of one of their license plate readers triggered them to pull her over. Let me make this clear. You need probable cause, or in some situation, a Terry stop to pull a vehicle over. We do not know what those uniformed officers were doing when they pulled over this female. They could have seen her break the center line, miss a turn signal, roll through a stop, all reasons for a lawful traffic stop in all 50 states. What I'm saying is we can't assume we know the basis for the stop. If there was no probable cause for this stop and detention, this driver could have had 1,000 pounds of drug in the car and it would all be dismissed. What I am saying is we don't know for certain why these officers pulled this woman over, and for us to, in the affirmative, say it was a license plate hit for an abandoned vehicle is not fair. There are dozens of other reasons that the officers could have legitimately pulled this woman over. Anyway, thanks for your time, and I love your show.
Well, I appreciate the comment, and I think in the story itself it was related to the license plate because the vehicle had been towed or something like that. But the Deputy U.S. Marshal, former Deputy U.S. Marshal, is correct. They will pull you over and they'll invent the reason later. And if they can't invent a reason legitimately, they will make up stuff like, well, you drifted over the center line. Everybody does. If you follow someone long enough, persistently enough, they will drift. I mean, that's what
they'll do something that gives you reason to pull them over.
But what Chance and I were trying to suggest strongly was that she should have kept them on point and just saying no thank you. And I would have continued to give the same advice. If you encounter a cop, I want you to deal with the reason for the stop. I'm not your friend. I'm not going to have small talk with you. I don't intend to tell you my life business. I'm not even going to tell you what I'm doing, except for maybe some vagueness about what I'm doing. I'm on my way home. Where did you come from? I'm on my way home, officer. It's like, I'm not going to go down that path because it only goes downhill when you go down the path.
I'm with you. Chance, any other comments to go along?
No, I also appreciate that comment. And, apparently he knows what he's talking about. And, but again, it isn't how you guide it along, and it isn't brevity. It is how you handle yourself after the stop that really counts the most.
So
very good.
All righty. Well, so now we've got two questions combined into one coming up, right?
Yes, that is correct. So Dave wrote in a question, and then Evie also asked a similar question. So we are just going to kind of take them all just from what Dave wrote. It says, hi, Andy and Larry. Didn't the Wisconsin Supreme Court rule on this in RM292? Now some lawmakers want it to mean multiple convictions stemming from the same incident. Having two or more convictions causes one to be labeled a SVP and requires lifetime GPS at a cost of $240 a month, and maybe more now. For what it's worth, until 2017, when the AG reinterpreted this section of the SVP law, separate occasions meant, well, separate occasions. When I was state contact for Wisconsin, this reinterpretation generated over 240 letters and emails for me. Does this bill stand a chance? I probably should have the Clinton laugh queued up for this one.
So, well, I think he's talking about Senate Bill 874 in Wisconsin, and it absolutely has a very good chance of passing because there won't be any strong opposition that'll surface. You've got the probation and parole department there that wants it interpreted the way that it's interpreted. They are the ones who solicited the Attorney General's opinion letter. Now I'm going to talk about Attorney General opinion letters, and basically they're worth about a bucket of warm spit. That's why they're called an opinion letter. But they're given a higher amount of regard from the solicitor of the opinion letter. And here in our state, it has to be a lawmaker, or I believe an agency that requests review because they have the duty to execute and perfect the law that's been passed. So they ask, who would you, I mean, you wouldn't ask the sanitation engineer. So who do you ask? You ask the Attorney General, hey, what does this mean? We're a little unclear. Well, the previous Attorney General rendered that opinion that separate occasions meant separate occasions within the same case. But the Wisconsin Supreme Court recently held that separate occasions meant that you offend separately in separate cause of actions. And that's not what the way that they were applying it. So people who were subject to that monitoring, unless they had two separate case numbers, theoretically have been removed from that obligation. Theoretically, I'm not in Wisconsin, but I don't know for sure. But that theoretically, the Wisconsin Department of Corrections have taken the action to remove those people. This is the lawmakers wanting to clarify what they meant, which would ultimately neuter the Supreme Court ruling, because the Supreme Court doesn't get to decide what the law should be. They get to interpret what the law is be. And they interpreted that language to mean on separate occasions and separate case numbers. And the lawmakers in this proposal, I did a quick glance at it, and they're making it clear that they intend it to be multiple convictions even within the same case. So it is very likely to pass, in my opinion. Governor Evers will sign it if it makes it to his desk, because of the political fallout would be horrendous if he didn't. So if you guys can't figure out a way to kill it in the legislature, you're going to have a whole new problem, probably by later this year on the effective date of this law.
Do you think there's any chance that anybody in Wisconsin will get forth and kill it?
I don't know enough about how the process works there, other than I know general politics quite well. I don't know who the opponents would be that would step forward. I just can't imagine who would be. The victims' advocates are not going to be against it, and they're usually a big part of the process. The law enforcement apparatus is not going to be opposed to it. I can't see the Department of Corrections saying, well, we just don't have time to I mean, I can't think of who any natural opponents be. Possibly a defense lawyers union association of sorts, the Wisconsin defense lawyers, possibly. But there's not going to be any really strong opposition that's going to surface. And when the committee chairs call these bills up and ask for public comment, and all the public comment is favorable, I just don't see how this is going to be voted down.
I see. And can you explain in a little bit different detail of having two or more convictions causes one to be labeled a SVP? So it means separate occasions. What are they doing? Like, what are they functionally doing?
Well, suppose you had three counts within the same case. What the Wisconsin Supreme Court decided was that did not mean separate occasions. Now, literally, it could mean separate occasions. You could have three counts in the same case, and one could have happened in 2017, another one could have happened in 2019, another could have happened in 2022.
I gotcha.
And those could have all been charged in the same case, and it could have been separate occasions. But the way that the Supreme Court interpreted it was that you had to had been subject to separate prosecutions and been convicted independent. Now, to me, that might encourage prosecutors would have encouraged prosecutors to be more creative in terms of how they file charges. And Chance can weigh in on that, because if they know they can put you on lifetime GPS monitoring by having by prosecuting you on two separate occasions, if that's the magic formula, that's what they would likely do, if that's their goal.
Chance?
Yeah, that's probably true. I mean, it is, the comment that Larry made about, the opposition is really a good comment. Because it really, that's, when you're talking about trying to stop something like this, sometimes the cost of trying to enact something like this is, makes, in the process is far greater than actually implementing, what people are saying in terms of pushing this and implementing it. And you can only do that when you have opposition and you've thought it through and you're thinking about, how legitimately to oppose it. It always comes down to an opposition smart thinking about what the costs are of doing whatever you're proposing to do. And that has to be done in these meetings, and it has to be done in a way that makes sense to everyone. so that, it can be shot down before it gets too far. Usually, in California, we have public safety meetings, and, those types of things are discussed, what it's actually going to achieve and at what cost and whether or not it's worth it. So there has to be some kind of pushback. Otherwise, you're really backloading it. You're hoping to then shoot it down via constitutional challenge. And I don't know enough about the bill to say that it violates, due process, equal protection, or whatever. I'd have to really look at it closely, but that's an uphill battle. That's a tough battle. And when you think about it, separate occasions and what an SVP is, this is a very, very tough terrain. That's what I think.
Certainly that. Anything else before we go on, Larry?
Well, I feel bad for these people because, in my opinion, unless something dramatic is taking place in Wisconsin behind the scenes that I don't know about, this bill, I can't see what the barriers would be towards it being approved. And it's the people's prerogative to designate SVPs how they see fit. And of course, the presumption is that it's constitutional. There may be some constitutional arguments that could be made downstream after it becomes law, but there's no order that any court can issue to tell the legislature not to legislate. They can legislate any damn thing they want to legislate whenever they want to do it. Or they can refuse to legislate. And we've learned that from following cases here when people say that the court gave the legislature 6 months to legislate. You can give them 30 years to legislate. They don't have to do a damn thing. So that's the thing about the separation of powers. They can't tell them to legislate. They can only tell them what happens if they don't. You remember the Michigan Registry when they told them that they had to legislate within a certain amount of time? They can't do that. And they didn't legislate. But then when they finally told them, well, the registry is going to go dark on a date certain if you don't, then magically they legislated.
How about that?
Yeah. Yeah. But it's important, though, if there are issues of constitutionality and issues of cost, that someone will push back and bring it up. So at least it can be thought through, before any final decision is made, because sometimes those are the things that cause a bill to go away. But once a bill is in place, that's a whole different story. And, that is a tough terrain, to challenge these laws and such, but don't know enough about it to really analyze it constitutionally to say there's anything there to do that.
Understand. So we'll move along then. We're going to go over to Arkansas. This was a question asked by Jacob. It says, I was convicted in 2010 in the U.S. District Court of the Western District of Arkansas on PFR-related charges. I am a level 3 offender, and though I have a while to go before I can get off the registry, I do have questions. Sorry for the long statute. Under Arkansas ACA, Arkansas Criminal, what would that be, Larry? ACA.
Arkansas Code Annotated.
Oh my God. Okay. I never would have gotten that one. All right. And look, I got 12-12-919, then a B, then a 1, then a big B, then a Roman numeral 2, then an A. I don't know how to read that, Larry. That's too many things together.
I don't even know how to read that, and I get trained. I've been trained to do this, but you got too many. When you have the capital B and then you got the lowercase b, I don't remember what that means.
It's like paragraph this, subparagraph that, subparagraph.
Wow.
Screw that. All right. Anyway, I gave it to you, and it'll be in the show notes later. And it states, no less than 30 days before the date of the hearing on the application under subdivision lowercase b, 1, and then capital A of this section, a copy of the application under subdivision B1A of this section shall be served on the prosecutor of the county in which the adjudication of guilt triggered registration was obtained if the PFR was convicted in the state. Could they word things more complicatedly, Larry?
Seems perfectly clear to me.
Okie dokie. All right, then to continue. The issue is I was convicted in the same federal district as where I was sentenced, but a different county. I am from Franklin County, but was sentenced federally in Sebastian County. So based on the reading of the statute, do I have to notify the Sebastian County prosecutor, the federal prosecutor, the Franklin County prosecutor, or technically neither county prosecutor since it's a federal case. And thanks for your time and, of course, FYP.
So I called the guy, and I enjoyed this question so much because some people can invent things to be worried about and crazy stuff, but this is actually not totally crazy because he's reading from the statute, and I have researched that statute, not today, but I've researched it in the past, and it does say what he says it says, but I don't think it means what he thinks it means, and but it does say that. So Arkansas, like several states that have removal processes, if you were convicted in a circuit court in Arkansas, you have to go back and file your petition for removal in that circuit court, and you serve it on the county prosecutor of that jurisdiction, similar to what you would have experienced in Georgia. No matter which of the 159 counties you chose to live in, your Georgia conviction would have gone back for the removal petition to your county of conviction. But had you been convicted in a non-Georgia setting, either federally or in another state, you would file it and serve it you'd file it in the county you're living in. And I think that's what this means in Arkansas. But since I'm thinking it, doesn't mean it's so. So he would be well advised to consult with an Arkansas practitioner. But if he's got to serve it on someone, there has to be an adverse party to this because it's an adversarial process. You don't just file a petition and the judge says, oh, well, nobody got served, I'll just grant it. Someone has to be served. But if it were me, and if I held a license in Arkansas, I would tell the gentleman, barring any case law on point to the contrary, I would tell the gentleman, well, you have a non-Arkansas conviction, so therefore we're going to file it in your county of residence, and we're going to serve it on the prosecutor in the county of residence. And that will be the responding party. And that prosecutor, having never been connected to this case, may not have any anxiety whatsoever because that's going to be a state of Arkansas prosecutor, and he was prosecuted by the U.S. Attorney's Office. Very few people go backwards if they're assistant United States attorney, they don't generally give up that coveted assignment and go work for a state prosecutor's office. It just flows the other way around. You work for a state prosecutor office and you get a job with U.S. attorney. So that prosecutor's not going to know anything about him. All they're going to know is what any information the sheriff where he registers has provided or will provide to them after the petition is filed. So that's what I think I would do. But this is a unique question because it literally does say you file in the county you're convicted. He happens to be one of the rare ones who was convicted in a federal district in the state where he's registering and where he's living. Oftentimes, they were convicted in one federal court, and the Bureau of Prisons, the BOP, put them in an institution all across the country, and they don't return back to where they were convicted. But this is one of those unique circumstances, so he needs to figure out if there's any case law on point. And for a small fee of $10,000, I'll research that for him and give him an answer.
Wow.
And Chance, you're not going to undercut me on your fee to do that research, are you?
Oh, no. I wouldn't undercut you a bit. But I do think that, it's a very good idea. Not only look at it and consider it, but to get some advice, from someone who does these types of things in that state, and guidance on how to go so that you save a little bit of time and effort.
So I think when we were on the phone call with him, I did research Franklin County, and it's a very small county, I think population of 17,000. And it's not going to be a bastion. Most 17,000 population counties that have been stagnant at that level for 40, 50 years, they're usually not a bastion of liberal and progressive thinking. But that doesn't necessarily mean that they're going to deny the petition. But that's research you would want to add to the list. You want to find out how many people have been removed in Franklin County. If you can get some data on that, and a practitioner might be able to get that information easily and say, well, actually, my colleagues and I, we've been bemoaning this. We filed in the last 5 years, we filed 24 petitions, and not one of them has been granted. If that be the case, then I would suggest you do some research about places you might want to live in Arkansas, because my opinion is that you can file in the county you're residing in since it's a non-Arkansas conviction. So barring a legal barrier, I would pick up myself and get out of Franklin County when the day comes several years in the future, and I would file it there. The problem he has is that this system that Arkansas has is very expensive to administer. And there have been bills through the years in the legislature to dismantle the risk-based system, because they spend a whole bunch of money providing due process and doing these psychosexual evals over in Pine Bluff, and they want to just get rid of it and go to the categorical approach. So what would be hilarious would be if he's in the 14th year of the 15-year registration period and they abolish it and he can no longer file.
Chance, anything that you want to add to all that?
No, but I knew it. Not really, because I think that Larry covered it pretty comprehensively. Other than that, just to emphasize that legal culture is really a consideration here. And if you're in a place where these things just aren't happening, and you can, shift to a place where they are, common sense tells you go where you need to go.
So,
All right. So I guess, on to the main event. And I guess you guys really have this thing all teed up that we're going to be talking about frightening and high. Who wants to start?
I'll start. Tell me, Andy, what was that conversation you had with your kid?
Oh, well, so well, what are you going to talk about tonight? And I said, oh gosh. Well, so what I know about the frightening and high, and I hope that I have this right, is that from a Psychology Today article on a very small subset of the worst of the worst of the worst kind of offenders, that this evidence was presented in court at the lowest of levels, and then due to summary judgment, it just kind of gets passed on and on and up. And then our people say that the Supreme Court says, but they never found it. They just carried it. It was inherited all the way down. And then it gets cited in all of the subsequent papers and references that PFRs have a frightening and high chance of recidivating. And that's not really how that needs to be presented, because it was on this very small set of people from kind of a junk article about a very small set of PFRs. That's what I understand it to be, and kind of explain that to him. But boy, is it complicated.
It's hard because, when you're explaining this frightening and high, it's like the snowball that never was, but it rolled down the hill and got very, very big. But let's take a look at some of the background on it before we get started. So, Larry then can pick this thing apart from his point of view. And the first thing to know about this is that, driven by a pervasive fear of sexual predators and facing almost no discernible opposition, as we have discussed before, politicians have become ever more inventive in dreaming up ways to oppress those forced to register through state and federal legislation. And when these laws have been challenged in court, they've been justified based on the Supreme Court doctrine that allows such laws, thanks to the quote unquote as high as 80% recidivism rate ascribed to untreated sex offenders by Justice Kennedy in a case called McCune versus Lyle. And that's a 2002 case. You'll find it at 536 US 24, page 34, which then morphed into frightening and high risk of recidivism posed by sex offenders in Smith v. Doe, which happened the year after. That's a 2003 case, and you'll find that at 538 US 84. The problem is that 80% recidivism rate is an entirely invented number, which comes from a Psychology Today article published in 1986. That article was written by a treatment provider, not a scientist, but a treatment provider who claimed to be able to essentially cure sex offenders through innovative adversive therapies, including electric shocks and pumping ammonia into offenders' noses. Justice Kennedy found that particular number, which is 80%, in a brief signed by Solicitor General Ted Olson. The brief cited a Department of Justice manual, which in turn offered only one source for the 80% assertion, and that was the Psychology Today article published in 1986. The article offered no real way, scientific or otherwise, to fact-check the 80% assertion that was made in it. Because that 80% figure suited the government lawyer's aim of cracking down on sex offenders, Solicitor General Olson cited it, of course. And Justice Anthony Kennedy conveniently adopted the figure without question in 2002 and carried it over to where it morphed in 2003. As a result of its application in Smith, laws based on the Supreme Court's baseless, frightening, and high doctrine has done long-lasting damage to well over 1 million sex registrants in our country. Now the question is, did it really have to happen that way? What do you think, Larry?
Well, before I go into it, if I remember right, Solicitor Olson died in 9/11. I know he died an untimely death, and we're all sorry for that. But I don't remember the circumstances. But he's no longer with us, and he died suffered an untimely demise. You don't wish anything bad on your opponents, but as he would have been the representative of arguing the case on behalf of the United States, at least his office was, whether he was personally there. But no, it didn't have to be that way. I don't think it had to be that way. But I'm not even sure where to begin, because my issue has always been that the Supreme Court did not create the notion of frightening high recidivism in either Smith v. Doe or McCune v. Lyle. That fact was handed to them by the parties in terms of how they handled the litigation below, meaning at the trial court and at the Court of Appeals. And I'm quite certain that all of us are familiar with the rules pertaining to summary judgment. A party that moves for summary judgment tells the court that there are no material facts in dispute and that no trial is needed for further factual development. In addition to that, the court must resolve any doubts in favor of the non-moving party, meaning the party that says, Judge, we don't need to waste your time. We can rule this case, you can decide this case on the briefs. Everything that was in the brief of the non-moving party, if it's any ambiguity, it's resolved, that ambiguity, in favor of the non-moving party. So I have a little doubt that in Smith versus Doe, although I haven't read the briefs thoroughly, and in McCune versus Lyle, I haven't read those briefs thoroughly, that they raised the issue of frightening and high recidivism. So in both of those cases, it didn't have to be that way if the parties had said, well, Judge, we'd like to go forward with a summary judgment, but the state has argued frightening high recidivism, and we dispute that. That is not a fact. The recidivism is actually quite low, and we're ready to put on testimony over a 3 or 4 day trial to show that that is, in fact, untrue. And they didn't do that because they assumed that in most cases, in their mind, they had it won because in Smith v. Doe, it was an ex post facto argument, and they figured that that would carry the day, and they had not apparently read Kennedy versus Mendoza-Martinez in 1963 about an ex post facto challenge. It's not really ex post facto if it's civil and regulatory. It is not intended, or if it doesn't actually in effect impose punishment. And in the McCune versus Lyle, which I'm going to get into reading a little bit from that later, but the same thing. There was factual development that needed to have been done, but they were certain that they could win without factual development. And they were right. They did win in both of those cases below, but they didn't win at the final decider, which was the Supreme Court. They did win below.
That's correct. But and I'll say the Supreme Court didn't create this false notion. They perpetuated it. It was offered up in a brief which cited a Department of Justice manual, which in turn offered only one source for the 80% assertion. The Psychology Today article published in '86 should have been challenged and should have been developed. And that lesson has been learned. I think you can look at Michigan the Michigan challenges, and you can see throughout the country that amicus briefs are now being attached to these things, and the response is that we're just not going to have another situation like that. And I think that is the effective way of litigating in the future.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
So, well, I hate reading, but I'm going to try to do the best I can to read a little bit from the syllabus in McCune versus Lyle. And it says respondent, because he would have been the respondent since he had won below. When you look at a case, the party that's listed first is the party who filed the cert petition. So that is essentially the party who did not like the Court of Appeals decision. So respondent was convicted of rape and related crimes. A few years before his scheduled release, Kansas prison officials ordered respondent to participate in a sexual abuse treatment program. As part of the program, participating inmates are required to complete and sign an admission of responsibility form in which they accept responsibility for the crimes to which they have been sentenced, and complete a sexual history form detailing all prior sexual activities, regardless of whether the activities constitute uncharged criminal offenses. The information obtained from that SATP participants is not privileged, and it might be used against them in future criminal proceedings. There's no evidence, however, that incriminating information has ever been disclosed, according to the court. Officials informed the respondent that if he refused to participate, his prison privileges would be reduced, resulting in automatic curtailment of visitation rights, earnings, work opportunities, ability to send money to family, and canteen expenditures in excess of and access to personal television and other privileges. He'd also be transferred to a more dangerous maximum security unit. Now, that's a pretty significant threat to hold over a person. If you don't do this, we're going to do this. I mean, would you agree with that, Chance? That's a pretty significant hammer to hold over someone.
Oh, yeah, absolutely.
So he was in a position where he was basically in a no-win situation. Nonetheless, he refused. Now, I tell you, that takes some courage. When they tell you they're going to do all these things to you, and he refused, on the ground that the required disclosures would violate his Fifth Amendment privilege. And he filed for an injunctive relief. He filed a petition under 42 U.S.C. 1983. The district court granted his summary judgment. Remember, summary judgment. And the 10th Circuit affirmed the summary judgment that compels self-incrimination. It actually does violate the Constitution. But ultimately, Kansas won because they went to the Supreme Court. And the record that they would have had when McCune versus Lyle got to the Supreme Court would have been a very sparse record, because it was all done on the pleadings below. Maybe he should have, rather than being so arrogant, assuming that since self-incrimination is a legitimate constitutional right, maybe they should have done a little bit more research to figure out what the exceptions are and whether this would have fit within some of those exceptions, similar to what the exception was in the Smith versus Doe, the Kennedy-Martinez analysis of what constitutes punishment. But here we are because of summary judgment, in my opinion. There weren't enough facts established below.
Agreed.
So,
And that is frightening and high.
Very clever.
I still see many cases going up on motions for summary judgment that shouldn't go, because there are things that are in dispute. There are facts that have not been adequately established. The case out of Colorado, where Judge Mage, he's now deceased, but that very important case challenging the registry was sorely lacking in evidence. Although there was a trial, there wasn't any evidence because the lawyer didn't have any money. But there's an attorney based in North Carolina that filed a motion for summary judgment on a frontal assault on the registry. And the judge denied it because the judge said, I see facts here that haven't been properly developed. So the judge saved the lawyer. I mean, ultimately, the case was still lost, but the judge said, I deny your motion because I see that there are facts here that haven't been clearly developed. Why are people so hell-bent on avoiding trial? You've been practicing for 42 years. Why do they want to do everything by summary judgment?
I think there's a great, one, I think they are limited by resources. And two, they cut corners. Or three, they're just lazy. Or four, they don't know any better. And it makes for a lot of bad law. That's just the case.
Larry, going back a bazillion years, like the origin of our relationship was judicial economy. Wouldn't that summary judgment fall under that kind of philosophy of it just makes it more expedient to move the cases through court that way?
Oh, absolutely. It's efficient. But remember, you have a duty to do the best for your client, not the most efficient for you. Now, if your client can't pay the bill, that's a different matter, because if you're doing it on the hopes that you're going to win and get a payoff under 1983 later, well, the more you have to do in advance of this case, you're going to have more to lose if it goes against you. So I'm guessing, since I've never practiced law at that level, I don't know what how you would analyze it. Well, if I have to prepare for a week-long trial, Chance, it's my opinion that every day you're going to be in trial requires a day of prep to be ready for that day of trial. So if you're looking at a 1 week trial, you got to at least do a week worth of prep, at least.
Let's put it this way: if I'm preparing for trial, for every hour I spend litigating, I spend 3 hours preparing. If you think about it in those terms.
So they may be looking at the loss is going to be horrendous, because under these 1983 claims, they're not going to get paid unless they're a prevailing party. But I want to win, and I tell the client, if we need financial resources, we can't do this case. We just can't do this case, because this case is going to require a lot of money, and our little firm just doesn't have the money to carry this case. Although we believe in you, we believe in your issues, but we need a budget of $50,000 for experts. Do you have that? Because we don't have it to front you. We just don't.
Let me jump in and ask, what is, I actually do kind of know this one, but what is a 1983 claim? You keep throwing that out there. What is that actually going to talk about? Chance, probably you, because you have the law degree and all that stuff.
Well, no, I'm gonna pass this on to Larry, because I'm not familiar with 1983 claims, because I don't
really.
Do them. Yeah, I don't. Those are federal claims, right, Larry?
Yes, that's a section of the United States Code that provides for civil rights actions, and there's a provision in 1983 claims for the prevailing party to recover the attorney's fees. And I don't know if California has a similar provision in their civil litigation, but yeah, it's a way to recover. And people like to use 1983 claims because the federal judiciary is theoretically more insulated from the political whims. You don't have too many Judge Perskys in the federal system. They're on the bench under Article 3 of the Constitution for life. And like them or not like them, there's not anything you can do about it. There's just some gross malfeasance. And I mean, in terms of my lifetime, it's been maybe 2 or 3 federal judges I can remember that have been impeached or removed. It's exceedingly rare.
Correct.
All right. Are we done with this section?
Well, I think we could probably do a little bit more development on the issue of frightening and high recidivism. It is in every preamble legislative enactment about frightening and high recidivism. The National Conference of State Legislatures, they pump out this model stuff among others, but the National Conference of State Legislatures pump out this stuff in terms of model bills. And this is in ours and in Mexico. It's probably in every registration scheme around the country about the legislature fines. Now, I tried to strike that this year in a bill that we're working on. And much to my surprise, the State Department of Public Safety, they rejected it. I was going to strike everything in that preamble in my version of the bill. I struck the entire preamble, and it said the purpose of the Sex Offender Registration Act is to comply with the federal animal child safety, or whatever the title of that is. That's what I had in my preamble. And Chance, aren't you surprised? They wanted to leave that legislative finding in there. So the bill that, as it's currently working through the legislature, has that preamble contained. I'm going to try to strike it as an amendment, because there's no frightening and high recidivism, but it's in every legislative enactment. The legislature has found frightening and high recidivism.
But they're just citing to the Supreme Court piece, right?
Yeah, that's the snowball that never was, because when it happened, in Smith, it was small and it began to roll down the hill, and now it's huge. And you're right. But I look at that as a rebuttable presumption. I mean, frightening and high, the Supreme Court's crucial mistake about sex crime stats done by Ira Ehrman completely rebuts that. And not only does he rebut it, and he is, I think, preeminent in that. I mean, he is a respected and credible researcher. And if you look at his article, and it has been used, in litigation across this country, in amicus briefs and such, you'll find that it totally rebuts that presumption, and should be used in every single way in litigation, in state and federal litigation, and also in legislation. I think that it should be recognized because it really takes down that foundational brick that justifies all these other things that oppress, all these other laws, rules, regulations, and so forth.
Well, my goal is to remove it from our preamble because there's no basis for that to be there. And I've learned through the years of being in the legislature that the victims advocates come in and use that. And they use it as a hammer to hold over the lawmakers. They say, well, look, you've already found that these people pose a frightening high and they're a danger to the community. And I saw a senator that I'll choose not to name said, I don't care about that. And I'm thinking, well, gee, you said that publicly, and it's going to be used against you, and it hasn't been yet. But that it should not be in there because it's just not factually correct. But it's also not factually correct to blame the Supreme Court for it in its entirety. What would have been some options that the Supreme Court could have done that would have minimized or diminished that? Based on the posture of the litigation, being that this came to them on summary judgment, being that both Kansas and Alaska did not get the chance to test their defense, what could the Supreme Court other options have been rather than doing what they did? Could they have kicked it back down for further development? What would have been a better outcome from the Supreme Court?
Well, they could have. I mean, they certainly could have, or Justice Kennedy, starting before Smith versus Doe, instead of taking it for what his use was, okay, could have at least background checked it. He could have fact checked it. He could have had his clerks look at it and really develop it before he stated it, okay, because it really is intellectually just horrendous. I mean, it is a fallacy, and it has no foundation, and it should never have occurred in any opinion. So I think that part of this is the fact that he just didn't fact check that assertion, just used it in order to justify some things that again have rolled downhill and become this like monster. But yeah, further development, and two, at least fact checking it before using it in an opinion.
Well, it would be my opinion that the Supreme Court's justices very seldom do their own research. So I would think that his law clerk is who found this for him. But the law clerk probably found it because the law clerk was asked to find something, because that meant, in my mind, Kennedy was leaning towards ruling against a sex offender and in favor of the state of Alaska, or in the case of Kansas, against the offender in favor of the state of Kansas. So if the law clerk was told, you find me something, this is what I need because this is where I'm leaning, that I think is probably a more likely scenario of how it came down than they. Do you think that they actually do their own research? I suspect that most of the research is done by the clerks for the Supreme Court justices.
Well, I suspect that you're probably right. I think maybe some unique justices do their own research. I think that they also rely on their clerks mostly. And I think that they set out the parameters and guidelines of that research. And, those who really want to know what they're talking about, want to get a full view, both sides of the equation, before they make a bold statement that may impact people for a very, very, very long time. I think it was reckless. But I do agree with you that I think that he was looking for a way to get to where he wanted to go. And I do think that that's probably the likely scenario.
Well, you and I probably are one of the few people still alive that remember the series, TV series, The Paper Chase from the 70s.
Oh yeah.
And but the mythical Professor Kingsfield would have read that, and he'd have said, "What is your source for this?" before I put
Absolutely.
before I put this in majority opinion, what is your source? I mean, he would have been a tyrant on that because that's just the way he was portrayed in the show. But that's what a good justice would do. When something like that comes before them, they would have said, I see that as, hey, I need to see where this comes from and how credible it is, and if it's been peer reviewed, because if we're going to adopt frightening high recidivism, although this was decided on summary judgment, I'm not going to use it as a basis in its entirety unless there's something validating this. That's something I think that Justice Kennedy could have done.
Well, he could have done it. I mean, there's an old saying we had in law school: you get Cardozo'd, and there was a Supreme Court Justice Cardozo, who, instead of doing that, drew a line from A to B where he started and where he wanted to go, and then built everything in to get to that conclusion. And that seems to be what Kennedy did.
So, well, we've got time for your.
It's a shame because you know what? A year later, he took everybody with him. It's everybody. So, just wrong.
Well, I think we then have chance that you could do the follow-up for that additional question that was asked for the California corner.
Okay, the California corner. Is that okay with you, Larry? You want to do?
Let's do it. Let's do it.
Got a few more minutes here. I'll do that as a follow-up to what we spoke about maybe an episode or two ago. And we were talking about petitioning for removal in California, and this comes up. This is a follow-up, and this is an update. And I think that a lot of folks ask this question and get caught in it sometimes in the wrong way. But the question is, can you apply for removal in California if you are residing in another state? And the answer is yes, and the answer is no, because it comes down to how you do it. It's no, you cannot petition if you reside out of state. And let me give you an example. California, a man named Clifford James Smith, however you want to pronounce that, was categorized as a Tier 2 sex offender, and he sought to be removed from the California Sex Registry. However, at the time of his petition, he was living and registered as a sex offender in Oregon, not California. The Superior Court of Glenn County, of all places, denied his petition, stating that he was not currently registered as a sex offender in California. On appeal, Smith argued that the denial of his petition violated equal protection and was contrary to the legislative intent of California's sex offender registration laws. The Court of Appeal of the State of California, 3rd Appellate District, affirmed the lower court's decision. The court found that the California law, which was restructured to establish 3 tiers of registration for sex offenders, only allowed people registered in California to petition for termination from the California Sex Offender Registry. The court disagreed with Smith's argument that excluding out-of-state registrants from obtaining relief was contrary to the legislative intent and was just absurd. The court reasoned that as someone not registered in California, the legislative concerns did not apply to Smith. Okay, so it's an absolute no if you're not living and registered in California. It's a yes, either by residing in California or establishing a second residence in California. So if you're an out-of-state registrant and you want to petition off the registry in California, establish a residence in California. If you want to take your California conviction and you want to petition for it out of state, then establish a second residence in California. And you can always get advice from an attorney who does these things in California on exactly how to do that. And I'm going to note 2 things which I think are really important. One, you must include the out-of-state residence on the California registration form if registering in both places. Very important you understand that, because on that form, it says places where you register. A lot of people confuse that by thinking that's only places in California. No, if you're registered in another state, let's say you have a California conviction, you're in Oregon, you want to get off the registry in California, you want to keep both residences, and you established a second residence in California, all you need to do is put in that box, your other address where you register at. That way you can move to and fro and still keep your established second residence in California for the purpose of being removed from the California registry. And 2, during the process of removal, you've got to serve agencies, and what I mean by agencies are the registration agency and the prosecution agency of that particular jurisdiction, and also your outside agencies, meaning the ones outside the state, as part of the petition process. Why? Because California law requires it in order for the removal process to move on, because they have to establish eligibility. And 2, they're asking for input. So what does this really mean? What this means is that even though your outside folks in the other state are probably not going to respond and are disinterested and don't understand California law, if they have any input at all, at least you give them a chance by serving them with the petition to respond. If they don't, within 60 days, you're good to go. Then you're only relying on the agency you're registering with in California. But it all has to be done according to plan. And those are things you have to consider if you're going through the process. And that is the answer to that particular question.
I love it. Yes and no. So
yes and no.
Typical attorney. It depends.
Andy used to tell me that's as clear as mud.
Right.
So, well, on a funny note, I have a person, don't remember his name, met him about 10 years ago up in Seattle, and he was the best pro se litigant that I've ever seen. He was the best brief writer of a person that didn't have a legal background. He could outright me in terms of how well he composes briefs, and I don't know where he got the skills to write, but he comes to me and says, I want to, basically he wanted to state shop and figure out all the states he didn't have to register, and he was calling the states to get them to opine on his Washington conviction if he'd have to register there. And he told me, he said, well, I'm going to file in Hawaii for declaratory judgment. I said, you're wasting your time. I said, I'm going to answer that. If I'm the respondent, I'm going to answer that saying that you're not registered here. You're not required to register here. You don't have to register. And we don't be bothered with you until there's this is not a ripe question. And he figured out how to bypass my concern. He put down in his petition for declaratory judgment, he filed a petition for declaratory judgment. He asked the court to rule whether he would have to register, and he said that his business took him to Hawaii on multiple times, frequently enough, that this was not just a theoretical controversy, but a real controversy. And he got a court in Hawaii to rule on whether or not he had to register, and he'd never set foot in Hawaii before.
That's interesting. That is interesting. Very creative.
I learned not to be so arrogant, telling people, I said, you're not going to even get I said, I'm going to come in and just can you on my responses, your issues with Washington, not with us. And he was able to get a Supreme Court ruling. I know a trial court. I don't think he had to appeal it because he won, but he was able to get a trial court to rule on something where there was no legitimate dispute between parties. And I thought, well, I just need to tone down my arrogance a notch or two, because I didn't think he could pull it off, and he did. And he just wrote such magnificent briefs. Where do you go to plagiarize to write that well? Because I've been doing it for 20 years and I can't write as well as he did.
That is a pretty cool story.
So, and does this AI write briefs for people? Because I'd like to charge a bunch of money that I can just put into AI and say I need a brief and get it done by the computer.
Somebody even said that before when we were talking about it. Oh, like the New York lawyer that didn't check ChatGPT citations. It completely fabricated citations in a brief that it wrote. Just made up. But it writes really well, Larry. And oddly, and I haven't played with this yet, but you could take everything you've written, even from your boss or from you, and you could feed it in there and you could say, write in this style, and it would write like it was you. It's really phenomenal what they're able to do these days. And it's only a year old. I can't imagine what it's going to look like in 5 years. Can't even imagine.
So, well, I generally poo-poo every pro se litigant, but in my years of doing this, I've seen a handful of people who are really quite good at what they write and how they think and analyze. And he was one of them. one in Maryland wrote a petition for declaratory judgment on the registry, and he filed a federal cause of action, and the federal judge liked it so much he asked the former chief public defender of the state to take the case for the guy, and she consolidated it into the work that she was already doing, challenging the registry. But occasionally somebody, even though they're not an attorney, they can actually do some pretty amazing stuff.
Yep. Yeah. Agreed.
So,
Well, anything else before we kick out of here, Larry?
I think we've covered it.
Fantastic. Chance, any parting words?
Just thank you for joining us. Appreciate it.
Well, thank you for joining us. We appreciate it. So there.
All right.
Well, make sure that you head over to registrymatters.co for episode listings, and then you can head over to FYP Education for show notes. Leave voicemail at 747-2277-4477 and email at registrymatterscast@gmail.com. And of course, support us over at patreon.com for just as little as $1 a month. And that is incredibly appreciated and helps keep the lights on, I suppose you could say. And as a patron, you could get on the Discord server and listen to us record live, which happens at about 7 p.m. Eastern on Saturday nights. And without anything else, I think that we can call this a good episode, and we will get out of here. And I hope everybody has a great rest of their weekend. And I'll talk to you gentlemen soon. Have a great night.
Thank you. You too.
Good night.
You've been listening to FYP.